Welcome to this special presentation that OMA is sponsoring. We try to do several a year, and Meredith is back again for a second presentation, so we're looking forward to it. I'm Susan Robinson, and I am the president at the moment of OMA, and I'm going to start a little bit of a slideshow to show you a picture of my fellow board members, because I don't do this alone. Now I can't get slides.
Hi. I'm just starting a Zoom, but I probably have 30 seconds. What can I do for you?
There are the, can you mute yourself if you're taking a phone call? We are a small board and we could use reinforcements, but we are dynamite. I hope you will agree. And we are so fortunate to have Margot, who a lot of you have been in contact with, and she's with us today. Jay is the only one of us that lives outside of the Portland area, and she is in the lower part of the state in Klamath Falls area, kind of a representative, distributing flyers, getting the word out there. But we could use people to represent in every region of the state and visit mortuaries if they want to, and get price lists and that sort of thing, but mainly to kind of be in touch with some of our members and do marketing and share the news of our workshops that we have. OMA is an old organization founded in 1961. It's an independent nonprofit organization. It used to be a member organization, but it's never been making profit really, always for public service, but it used to be a member organization. It is now we've become a broader, more public oriented organization and our nonprofit. And as you can imagine, the changes that we've gone through as the mortuary industry and the death care industry has changed so much through these years. I will say that Oregon's very advanced in the choices that we have, so we're very fortunate, but I think it's because of our organization and People's Memorial next door to us in Washington and the other funeral consumers alliances that we've been a leader. We've been around longer than many of the funeral consumers alliances in the nation. We're evolving all the time with industry changes and the new choices for funeral consumers. We're focused on education, but our members still in many areas do benefit from the discounts that we're able to negotiate with cooperating mortuaries. But we have always focused on advocacy and education. It's definitely what we are doing all the time now. Let me go ahead and invite Meredith Williamson, to whom we are so grateful for sharing yet another hour and a half with us to answer some of our questions. And I'm going to let Meredith introduce herself again, since many of you will not have met her before, but do notice that on our website, you will find a presentation about estate planning that Meredith did last year, I think it was. And there are several other presentations that I think you would benefit from too. Without any more time, I'll introduce Meredith, and she will talk to us about wills and whether we can write one ourselves without going to a lawyer.
Hi, everybody. My name is Meredith Williamson, and I am the founder of Northwest Estate Law. I have been a lawyer for over 20 years, but it was kind of a windy path to get here. I've been focusing entirely on estate planning and elder law for about 9 years, did litigation prior to my early 20s, back when that would be fun to do. And now I am a mom to 2 kiddos, age 13 and 10, as well as managing my law firm here in Portland. I have offices here in Portland, Beaverton area, and Southwest Washington. I'm licensed Washington, Oregon, and California, but only practicing really here in Oregon and Washington. And I'm going to focus today primarily on Oregon, but can answer some basic questions for Oregon and Washington both. So I am going to share my screen with everybody. Can everybody see my wills and estate planning screen?
Yes. Yes.
Yes.
All right. So these are my 2 kids and my doggy that passed last year. Hezekiah is 13. Evelyn is 10 years old now. And now I have 2 pugs instead of 1 Shih Tzu pug. So what exactly is estate planning? I think it's good to kind of take an overview first to answer some of the basic will questions. Typically, estate planning will include legacy, which is wills, which we'll talk primarily about today. Also could be something like revocable or irrevocable trusts, but it also usually incorporates incapacity planning. So what happens if we can't make our own decisions during our lifetime? And then often when working with a lawyer, especially an elder law lawyer, we're going to incorporate some healthcare and long-term care planning into those discussions. So the questions that we will sort of address today, and I will try to hit on every single one of them, but if anybody has additional questions, I'm happy to answer those at the end. But kind of, what is a will, right? Can I create it myself? What about handwritten wills? What if I don't really own property or much of anything? Do I still need a will? When should I use a lawyer? And some basic sort of what else should we know about estate planning? Again, because I think it's important to incorporate all of those other assets into our estate planning, the incapacity and long-term care. So legacy planning often involves wills, right? A will is the basic building block for incapacity planning. And a will really is just a document that it's like an agreement that we are creating with ourselves or the people that will take over after we die, to determine not only who is in charge of our estate, our stuff after we pass away, but how those assets will be distributed. I personally think everybody should have at least a basic will, but there are some people that a will or estate plan is really critical. And I've made sort of a list here. So if you have a disabled child or beneficiary, that could be a grandchild, a child, somebody, a sibling, right? Anybody who is receiving your property that has a disability. The reason for that is we want to make sure that we don't put their benefits at risk by inheriting property, because sometimes that is a bigger detriment to them receiving property. So there's ways that we can work around being able to give stuff to a disabled beneficiary without hurting them. Obviously, people with minor children, we want to make sure that we appoint a guardian in the event that a person passes away while they're still young. Families are a little messier now, right? We often have families from multiple marriages, kids from prior relationships. Anytime that there could be a conflict, we want to make sure that we have our wishes in place for people to follow. Also, beneficiaries who might not be disabled, but maybe have something going on in their life that it would be risky for them to receive the money outright. So beneficiaries with drug or alcohol problem, addiction, maybe going through a divorce. Anybody with assets of $1 million or higher here in Oregon is subject to estate taxes. So it's important to do some estate planning regarding asset preservation for our heirs if you have more than $1 million. And assets are going to include everything. They're going to include life insurance policies, if not going to a spouse. They're going to include IRAs, a house, sort of anything and everything that you're passing from you to your next in line is included in that $1 million threshold. So it's a little easier to reach that now with housing prices having skyrocketed in the last 10 years. People with assets in multiple states. Also there's a lot of people nowadays that don't have natural heirs, and I'll talk a little bit about who a natural heir is, but if you don't have children or parents or a spouse that would receive property, it might be more important for you to pick who will receive your property rather than maybe cousins that you don't have a relationship with. And then something that's coming up more and more is a need to appoint a professional fiduciary. So maybe there's nobody in your family who is appropriate to make financial or medical decisions for you during your lifetime, or nobody who can take on the role of executor after we pass away. And I'll talk more about what those different roles are here in a minute. Also, anybody with more than 200,000 should think about an estate plan, and I'll explain why later, but anybody with more than 200,000 in non-real estate is subject to probate. And anytime we have probate, we want to make sure that, your wishes are in place. Obviously, married couples facing long-term care. There's a lot of stuff that we can do to help preserve assets for family, help maintain assets for a spouse that does not need care when the other spouse does. Families of high conflict, anything that, could result in disputes, because that's just going to drag everything out. And often even, the best seeming families that have no conflict, there is something strange about death and money. It's this weird combination that can really bring conflict into a situation that may not have existed before. And generally, just if you want control over how your assets are distributed, that's best handled through a will or a trust or some other estate planning documents. Because again, you get to write this document out, and this document dictates who's in charge and how those assets are to be distributed. If we don't have an estate plan, there's rules of intestate succession. So the government outlines, and I'll go through those in a minute, exactly who will receive our property if we haven't stated our preference for who will receive it. And most of that it will be outright, meaning they're just going to receive it at the conclusion of probate as cash.
Could you quickly, Meredith, answer what is probate? A quick.
Yep, I have a slide for that, but I will really quickly tell you that it is the court process where our assets go from us to our next in line. So probate does require, in Oregon, court action, right? And it can be quite expensive and quite time consuming. So I'll talk a little bit about probate and the various kinds here in a minute. If you don't have an estate plan and assets go from you to your family members, creditors might not have had an opportunity to seek compensation from your estate. And so without probate, without any type of direct line where the court is involved, creditors may come after your heirs if bills aren't paid. So having an estate plan really kind of takes care of all of these pieces of it. So again, the will is really just a legal document. So like a contract, right, that you're creating. And in that, you're saying who's going to be in charge of probate after you pass away, who will get your assets after you pass away, how your beneficiaries will receive your assets. So again, this can be outright, meaning as at the conclusion of probate, beneficiaries just get the cash. You can also outline that things are left in trust and distributed over time, right? So maybe a beneficiary who is a minor or does have a drug or alcohol problem, you don't want them to receive the assets right away because they'll just be gone. So we can structure within the walls of the will how each beneficiary will receive the assets after you pass. Important aspects of the will. We want to make sure that if you trust your executor, that we waive bond. It makes estate plan, it makes the probate process a lot less expensive. Essentially, a bond is required because probate's intent is to protect creditors, first and foremost. And so the bond is an insurance that your executor, meaning the person that's either nominated in your will or the state says who can act if we don't have a will, that person is the executor or personal representative. The personal representative is responsible for overseeing all of the aspects of probate. I'll scoop ahead to the probate and then I'll scoop backwards just because I realized that it might be confusing as far what probate is. So in Oregon, if our assets are more than 200,000 in real estate or 75,000 in sort of cash account, so that could include everything that is non-real estate related, then a full probate is likely required. And probate is essentially a court matter, right? So it's public information where a judge oversees the person who's in charge of your estate, so the executor or personal representative. They're going to oversee the actions that they take to make sure all of your bills are paid, to make sure notice is given to everybody, so that the conclusion of that, everything has a nice little bow before your assets are then distributed to your beneficiaries. So with probate, there's a few steps. So number one is if we have a will, we present that will to the judge. That will is going to include who you wanted to act as your personal representative. So that person will generally work with an attorney to draft a petition and present the will to the court. That petition will basically say, dear judge, here is the document as the deceased person has already laid out. They put me in charge and they have waived bond, right? So can I be appointed without bond? If we don't have a will, then there are certain people who have preference in the eyes of the law as far as who has the opportunity to act as the personal representative. So that is often a spouse, a child, a family member. It can also be a creditor. So if nobody else has stepped forward to appoint themselves as personal representative, a creditor does have the opportunity to appoint themselves. Anybody who is being appointed without a will either needs a bond or we need to request that a lot of the assets are restricted. And what that means is that the personal representative has to sort of keep asking the court permission to access those resources to do things before probate is completed. After the executor, personal representative is appointed, then they're responsible to send notices out. If they're working with an attorney, the attorney will do that. They have to file an inventory, so they have to collect all the assets, figure out what all is going actually through probate, right? So bank accounts, maybe IRAs without beneficiary designations, real estate. So anything that doesn't have a direct line from you to your beneficiaries will go through probate. and then pay the bills, sell the house, kind of conduct all the personal representative will act in the decedent's place for making sure that the house lights are still on, bills are being paid, and selling the real property, most likely, sort of doing all the things that need to be done to gather the cash before it's distributed to the beneficiaries. At the conclusion of a notice period, which is 4 months from the date of those notices going out or notice going in the newspaper, then and only then can we can request the court to close probate, pay beneficiaries what they are due under either the will or the laws of intestate succession. And then we account to the court everything that has been done so far, ask for permission to distribute, and then receipts are filed and probate is closed. So it's a very formal process. It exists whether we have a will or not. There are ways to avoid probate, and I will chat about that in a minute. I'm going to scoot back up though to what happens if we don't have a will. Because again, whether we have a will or we don't, our assets will most likely be going through probate. So the laws of intestate succession dictate who will receive our property if we have not outlined who we want it to go to in our estate planning documents. If a person is married with children from the same marriage, then everything can go to the spouse. If there's no spouse, but there's children, everything will be divided among the children, or if there's predeceased children, that deceased child's share will drop down to their children. We call those issue in Oregon. Spouse and kids from a prior relationship, they split it. If there's no spouse, no kids, then we start going up the line. So our parents, and then out. So no spouse, no kids, no parents. Then it can go out to siblings. If everybody in that sort of small little bubble is gone, then assets will go to the state. So that is, again, why it's really important that if we don't have any natural heirs, I'm sure there's charities or friends or other kind of outlying family members that you would rather receive your property than it just go to the state. But it is nice that we have these rules of intestate succession. So if you don't have a will, the court will follow these rules for administering who gets your property when you pass. In Oregon, there are formal requirements that must be met for a will to be valid. It must be in writing. So it can't be verbal. It shouldn't be like written on a napkin. The writing must be signed, and the person who's signing it has to meet certain criteria. So with any contract, we need certain things, right? A person has to be over the age of 18. They have to have capacity to sign or be of sound mind. So what that means is that a diagnosis of dementia might be okay, but if the person no longer understands their assets or what they're signing, then it's too late for them to sign. And they also must be signing of their own accord. So nobody is forcing them to sign. There's no duress. Nobody is, telling them that they need to do this and who it should go to. So it needs to be their own idea, right? And that becomes important because if those three things aren't met, then the will can be void and the court can throw out the will. A will in Oregon should also have, it requires 2 witnesses in Oregon. Strangely enough, those witnesses can be beneficiaries under the will. So some states have stricter requirements that it can't be a beneficiary. Our state, that's okay. So the 2 witnesses, the witnesses must have their signatures notarized. So the witnesses and the notary page are basically under oath, right? That they saw this person sign, that this person was over the age of 18, of sound mind, not under duress. That then is presented to the court as testimony that the will is valid. And without that being in place, then there's a presumption that the will was maybe not valid. And that is the number one thing that I see in the risk of sort of the do-it-yourself wills. Most of them aren't properly executed. Most of them don't have those two witnesses and that penalty under perjury piece signed by a notary. So that is the number one thing that I've seen of wills coming to me from like a website or something they've printed from a notary company. The risk of that then is that the will gets thrown out, right? And everything that you've outlined, all the wishes that you wanted aren't being met because the will couldn't be proved. Oregon also does not permit what we call holographic wills, which are handwritten wills. Now, there's sort of an exception to that nowadays, but primarily it is best if a will is completely typed out and has your signature and those witnesses on there as well. Oregon now has this harmless error statute. So it sort of upends our no holographic will piece. But it must be still proved, right? Where, as I said before, if we have those witnesses sign under oath that you were over 18, that this was intended to be your will, then that is just proof in and of itself that the will is valid. Somebody else would need to come in and say that it's not a valid document. If the will is not compliant, so let's say it's a handwritten will and doesn't have the witnesses requirement, then it can still be presented to the court and we can still try to get it into the court. And I've been successful in getting, I think, all but one into the court that was not compliant. But we have to provide clear and convincing evidence that this was intended to be a will, even though it wasn't done properly, even though it might have not been drafted, though, statutorily correctly. Maybe it didn't have the witnesses, but enough proof that it was intended to be the will, that they didn't get rid of it, that they didn't do anything else later. And usually this is done through testimony of witnesses, people who recognize the decedent's signature, so collecting sort of all of these aspects. The downside of that is it can create a much more expensive probate, right? Because now I'm having to search out all these things that should have just been done when the will was created. A will does not avoid probate. I do think that's the number one misconception. Still goes through probate. It's just going to be less expensive because it's as long as it's properly executed, because everything's laid out as far as what your wishes were, who's in charge. We don't have to go out seeking waivers from anybody typically, because in and of itself, it says who's in charge and what should happen with your stuff. It also doesn't necessarily avoid estate taxes if they're applicable. So again, working with an attorney, if you have more than $1 million, becomes vitally important because there are ways to sort of alleviate some estate taxes. Oregon is $1 million threshold. So that means the first $1 million of yours is not subject to estate tax. Anything over $1 million does have an estate tax associated with it. Currently federally 12 million plus, like it's really hard to get there. Very few of my clients are over 12 million. That number is scheduled to sunset back down to 5 million here in 2026. So if you do have an extraordinarily large estate and it is over 5 million, you might want to consider just looking at estate planning soon. All right. So timeframe and costs for probate. Average probate right now in Oregon post-COVID is about 9 to 12 months. It costs about $4,000 to $7,000. A contested probate, meaning if somebody disagrees that that is your will or says you didn't have sound mind and now we're arguing in front of the judge to prove points of the will, that often takes years and can be very, very expensive. One thing that I want to point out that I didn't mention before, because it seems to be the thing that I've seen the most as far as contested, is the person who is living with a significant other but unmarried. There are no rights as a married person to your live-in partner's estate here in Oregon. And so that typically is the thing that I've seen the most as far as contested documents go. Somebody wrote something on a napkin or made a verbal promise, you know, to their girlfriend of 20 years, but didn't put anything formally in writing. That's been the thing that I've seen the most as far as contested probates go. So if you are under, so I think for a lot of people here, maybe, you know, even 200,000 is a lot of money, right? So maybe your estate, your total estate is really less than that small estate threshold. Again, that's 200,000 in real property or under 75,000 in personal property, which is going to include your stuff plus cash accounts. Or you have a revocable living trust and most assets are pouring into the trust. Our state has something called the small or now simple estate affidavit. You can do this with a will or without a will. The same applies though, intestate succession rules apply as far as who will get your property if you don't have the will. But this is a condensed, short, lovely version of probate where we simply give the court an affidavit saying, you know, either here's the will and we need to follow the will, or we don't have a will, but I'm a person who is entitled to receive the property and I will distribute accordingly. It is cut and dry. You can do it on your own. It is usually in the $250 range if you're doing it yourself, up to maybe $1,200 if you're using a really expensive attorney. And you essentially are just attesting that you have a right to receive the property. You'll pay the bills, you'll send the notice, and you'll distribute at the end of the 4 months. So for people, again, with less than, you know, maybe who don't own property or own a small piece of land, this is an appropriate and great way to manage an estate without doing a full-blown probate. There are some simple ways we can avoid probate altogether. Joint accounts avoid probate. So this is great, especially for married people, right? A lot of our accounts are held jointly. Putting beneficiaries on accounts that can have beneficiaries. So your 401k, your IRA, an annuity, life insurance. Adding beneficiaries is a direct line from that asset to your beneficiaries, pretty much with the supply of a social security number and a death certificate. There are times where beneficiary designations I've seen fail. And so if you're relying on beneficiary designations, I encourage you to just check them every few years. Bank accounts also have the ability to do something similar to a beneficiary designation, usually referred to as a TOD or a POD, and that means transfer on death or payment on death. So similar to a beneficiary, supply the death certificate and distributions are made. The number one pitfall that I see in utilizing this as your sole means of estate planning is often, you know, if you have 4 kids and you're only put one on it, that one child does not have any legal obligation to share that bank account with any of your other children. And the hope that they will do so, even again with the best families, or the families of least resistance, I have definitely seen it go wrong and feelings get hurt, and it sort of can tear families apart. So the reliance that one beneficiary will share it with everybody is often not followed through. Occasionally it is, but I've seen it go wrong more times than I'd like to admit. And then a revocable living trust is another method to avoid probate for anybody that owns real estate, especially. It's just an easier, simpler way. It is quite a bit more expensive than a simple will would be now, but it typically will save money in the long run. So it's a good option for some people. So why would you still need a will and probate if everything is listed beneficiary? So number one, again, is if you want to leave it to more than one person, I encourage you to actually have an estate plan that is written and not just rely 100% on beneficiary designations or TOD designations. Also, we need to make sure debt is paid off. And so if you have a substantial credit card debt, or sometimes we have unforeseen medical debt near the end, we want to make sure that that debt doesn't follow our beneficiaries, that it is managed. Also, if you do have a taxable estate, taxes need to get paid. So even if there's direct beneficiaries listed, somebody still needs to make sure those estate taxes are dealt with and the final income taxes are managed. This can be tricky if again, you have more than one beneficiary. Even if you've listed every single one of those beneficiaries, I have seen times where like one kid ends up paying all of it because it has to get done. And that's just really unfortunate for that kid, right? And then to either have to sue their family members or get them to pay, it can be difficult without sort of action. And again, just kind of any reason to keep a family cohesive after we pass is a good thing. And an estate plan really does that. Other reasons that I've seen probate need to be initiated is like a life insurance policy, or if somebody passes away in like a car accident and there's insurance being paid to the estate, it will often have to be paid into the estate. It can't go to the children because the children or other beneficiaries aren't a party to that action, meaning they don't have any rights to receive it. It's only the deceased person. Also, like big checks have come in and we've had to do small estate affidavits just to receive those big checks. So even with all of the planning involved, even with like a revocable trust or beneficiaries lined up perfectly, sometimes there are reasons that probate does need to be initiated just to receive funds into the estate. And also, again, if we have beneficiaries that are receiving any money that have a disability or are a minor or have one of those conditions we already talked about, we want to make sure that you're just doing the right thing by them and putting it in a vehicle for them after you pass away that doesn't put them at risk. So joint ownership. This is another question I get. Well, can't I just add my kids on to my property, right? My house. I'll just add my kids onto my house and that will take care of it. There'll be no need for probate. There is one major reason I do not like this, and then there's another reason that it makes it not great. So the first thing I do not like about adding or gifting money away is that there is a great opportunity for loss of that asset. So in the event your child goes through a divorce or is in a car accident themselves or is sued for some reason, that asset is part of their estate now and at risk of their creditors coming after it. Also, in the event that you need long-term care, it creates all kinds of entangled messes that need to be cleared up. If you need long-term care, Medicaid, or VA assistance to help fund long-term care. Also, it's not great tax-wise. So while they are not paying taxes when you give the gift, there is the best tax advantage after we pass away when we give real estate and brokerage accounts and things that have a tax basis. And what that means is if I buy a house for 100,000 and I sell it for 500,000, I am paying taxes or capital gains on the difference between that 100,000 and the 400 or 500,000. So taxes on 400,000. If I give it to my kids, I say I bought it at 100,000, I give it to my kids during my lifetime, they sell it, they also will pay capital gains taxes from the amount I bought it for. But if they receive it after I die, they get a new tax basis. So now if I die and it's worth 500,000 and they sell it that year, there's no capital gains on that. And so when we give major assets away that have this huge growth in value, we are just kind of burning that huge tax advantage for our heirs. So because again, the value of real property has increased so much in the last 10, 20 years, I don't love giving gifts during lifetime unless it's part of a overall plan. For other reasons, it's typically not the best thing to do to save a little money on not creating a will. Revocable trust, I'm just going to mention for a second. I don't think it applies to most people here, but it is a great way if we own real estate to be a vehicle to give that without having to go through probate. They are typically maybe twice as expensive as an estate plan with a lawyer. Plus there's work that you need to do during your lifetime, but they are cheaper in the long run, 90% of the time. Okay, I'm going to touch a little bit on disabled beneficiaries again, just because it's something that is near and dear to my heart. And wow, I've had a number of issues this month. Things come in waves as an estate planning attorney, and this is my month of disabled beneficiaries receiving money and us scrambling to try to make sure that we're not interrupting their benefits. So there are two major ways that we can, there's something called a supplemental needs, sometimes referred to as a special needs trust. If we are giving it to a disabled beneficiary from our assets, from your assets to a disabled person, that is a third-party supplemental needs trust. If they receive the money first and we have to put it into a supplemental needs trust, that's a first-party supplemental needs trust. The third party is far more advantageous for them both during their lifetime and then after they pass away. With a third party special needs or supplemental needs trust, we can give it to them. The trustee manages the assets. It can't be used for the things that Social Security is supposed to cover, which is housing and food, but it can go for all of their supplemental needs. Then when they pass away, and without benefits being disrupted, when they pass away, that money does not need to be paid back to the state. It can go to whomever the contingent beneficiaries are that you list in that document. With the first party supplemental needs trust, if they're over 65, it may create some issues for them, even if they're setting up this supplemental needs trust. It may cause a disruption in benefits. Also, when the state has to be a beneficiary, so there's payback provisions within that. So it's far superior to do a third-party supplemental needs trust with a little bit of thought ahead as far as leaving money to a disabled beneficiary. Often I see people just sort of like, well, I'm just not going to leave anything to that child or that person, and or I'm going to leave it to my daughter to take care of my son. Again, she has no obligation without it being in a trust to actually use any money. And just like when you had a joint account, it's now at risk with her creditors, or where it's not with the trust. There's trusts for taxable estates. There's trusts for specific assets. With estate planning, there's all kinds of stuff that you can do if you have unique assets or beneficiaries, again, that you want to, not just give everything outright to. So I think the major question was, do I need an estate planning lawyer to do this? No, you don't. But you need to make sure it's done correctly, right? So if you're not using estate planning attorney, I would recommend at least getting like a book on it, right? And make sure that it applies to Oregon law. So the number one thing, internet is great. We get all kinds of information. We can research stuff. We can become mini experts. The problem is there's a lot of misinformation out there. There's a lot of information that may apply to California, but doesn't to Oregon. And so if you are going to do it yourself, make sure that you are following the Oregon rules, right? That you're doing it right for Oregon. I would rather you have an incomplete estate plan than no estate plan, right? Especially if you have any one of those things that we talked about. It's better to at least have your wishes on a piece of paper in a document than it is to not have your wishes outlined at all. And that again is just to preserve your control and to make it easier on your heirs. Using a lawyer can be expensive, right? And not everybody has the means to afford a lawyer. So you can always talk to lawyers about payment plans or discounts. There are some clinics at senior centers that will often do free or discounted depending on your income. So there are ways to ensure that you're doing it correctly, to maybe utilize a lawyer and save some money overall, right? Because again, I do think that it is a lot less expensive in the grand scheme of things to have a plan be correct and executed properly than it is to not have anything or to have something not be 100% compliant. If you work with a lawyer, they're going to also do incapacity planning. So if you do nothing after this presentation, at least do this incapacity planning that I'm going to talk about briefly. A lawyer will also do long-term care planning, and it should be incorporated into one big plan, right? What are your wishes? What are your hopes? And then how do we make sure that those are outlined appropriately in these estate planning documents? So incapacity planning is going to, first of all, everybody needs it. Everybody over the age of 18 needs two documents in place: the power of attorney and the advance directive. They're critical because it's not just your stuff we're talking about, it's you, right? And making sure that you are cared for during your lifetime. If you lose capacity for the rest of your life, if you temporarily lose capacity, maybe you're even just traveling out of the country for a little bit and you need somebody to make decisions for you here. There's all kinds of reasons that we can predict and things that we can't really predict where you might need incapacity planning. So I've the youngest I've ever had is somebody came a week after their 18th birthday and we did these documents for them. But no matter a person's age, I want them to walk out of my office with at least this power of attorney and advance directive. Power of attorney is going to appoint a person to make financial decisions for you. Power of attorney is only good during your lifetime. So this is, again, something that is often confused. People think, well, I've executed a power of attorney. My son is in charge of my bank accounts and he can just distribute everything after I die. That's not how the power of attorney works. It's only good during your lifetime. If you only have the power of attorney in place and an agent over your bank accounts during your lifetime, their legal rights to help you die with you. So that's where the will comes into play, right? We need some legal authority for them to act on your behalf. During your lifetime, it's the power of attorney or trust. After you pass away, it's the trust and or the will. Do you need a lawyer for a power of attorney? No, not necessarily. But again, you want to make sure that you understand, I guess, for the will, for the power of attorney, for all of it, the number one thing is that your wishes are actually on that paper, right? And if you're working with a good lawyer, we should be explaining to you what it is you're signing. This is often in legal language and it can be confusing, and it's just good to have somebody in your court that will help explain things to you and be there if something goes wrong, right? If you have somebody do something wrong or a bank won't accept it, lawyers will often step in and make sure that these documents are willingly accepted from these financial institutions. So if you're going to do it on your own, again, I'd much rather you have it and have it maybe be wrong than not have it at all, because at least you should have an agent who can come in and assist you with a power of attorney. Make sure that person can balance their own checkbook, because if they can't balance their own checkbook, they're not going to do a good job with yours either. So, and make sure there's somebody who is trustworthy. This is not court supervised. And so I've only had one kid do something really, really bad. We had to file a police report, get him removed as POA, appoint somebody else. So make sure it's a person you trust and somebody that has the time and can balance their own checkbook. Number one thing to have, though, is the advance directive, which is appointing healthcare decisions. So putting a person in place. Effective as soon as you sign it, and your healthcare agent, the person who you're nominating to make medical decisions for you, signs it as well. There's add-ons. If you're working with attorney, you can write on that document if you're doing it yourself. It avoids the need for a guardianship, right? So the POA avoids the need for conservatorship. The advance directive should avoid the need for a guardianship. Those are, again, court involvement in your private matters, right? If we can avoid the court involvement in private matters, 90% of the time is going to be more beneficial for us and a lot less expensive. You absolutely positively do not need a lawyer to get the advance directive done. I have a link here and I can include it. I'll have them include it, OMA include it in when this recording is live, but it's available on Oregon.gov in multiple languages, multiple ways to fill it out. Every single person should have one of these. Make it a goal by Valentine's Day, maybe, if you don't already have your advance directive in place. Having a lawyer explain it or working with friends who have filled it out before is great, because it can be confusing, it can feel overwhelming, but it is vitally, vitally important to have the advance directive in place and then give it to your healthcare provider or your doctor. So without it, again, we're looking at guardian over the person to make medical decisions, conservatorship over finances. Like, it is best if we can just avoid all of the need for court involvement from the get-go. So if you're working with a lawyer, they should be covering all of this for you. Because again, just like probate, it's so expensive, right? It's $5,000 plus just to get one of these going. Court involvement, notice to family, just unnecessary in most cases, unless we don't have these documents already in place. Most of the time, people will come to me too and have, something they've printed off the internet, but they won't have the full suite of stuff. So if you're going to do it yourself, make sure you get the full suite. Make sure you're working on the Oregon Advance Directive and not some general one from another state. Make sure you have a power of attorney in place, and make sure that will has witnesses with their signatures notarized. Other things to consider when working with a lawyer is long-term care planning. This is typically looking at spending for care, primarily important, in my opinion, when there's one spouse that needs care and one spouse that is perfectly healthy. So we can pre-plan this well in advance. Somebody in their 50s, we can look at asset preservation. Most of the time people are coming to me in an emergency situation or looking at the need for long-term care in the short distance though. With all of this stuff, it is better if we can plan well in advance. So I encourage you to plan even if it doesn't feel like it's imminent. I'm not going to get into long-term care in this conversation, but I do offer a free monthly question and answer, either in person or over a webinar here in my office. The next one is February 22nd. So if you have questions on Medicaid, veterans benefits, general assisted living questions, cost of care, that kind of stuff, you can sign up and join me for one of those or a paid consultation if you aren't the kind that likes to raise your hand with other people around. Memorial planning, everybody I'm sure on this call is doing it well, but what happens after we pass away to us, right? Like making sure that our bodily remains are managed in the way we want it to be. This is all usually incorporated into a general estate plan. So having an estate plan gives you control over who's in charge, over who will receive your property and how they will receive the property. Generally saves money over time because it avoids probate. It may help with taxes. You're definitely going to get some advice on how to preserve more assets tax-wise. If you're over $1 million, if you're married, if you're looking at long-term care, and avoids the need for a guardian and conservator. Plus, you always have an advocate on your side. So once you have an estate planning attorney, even when the documents are done, you can typically give us a call and we will help walk you through anything that involves long-term care, anything that involves kids or estate planning or conservatorships or guardianships, that kind of stuff. You always have an advocate on your side. Again, estate planning can be quite expensive, so look for resources. You can call my office if you can't afford my services or work on a payment plan. I can refer you to the various senior centers and places that may have low income options available. If you can afford it, I encourage you to work with a lawyer though. It doesn't have to be me, it can be anybody. If you're post-retirement age, I encourage you to look for an elder law attorney because we're going to incorporate that long-term care piece as well. And there's an organization called NALA that you can find anybody who is an elder law attorney and part of that organization to assist you with estate planning. I think I hit all of the questions kind of a roundabout. It's all a bit confusing, so please ask questions, whether it's about how to execute a will or if you personally need a will or just general clarification on anything that I've touched on today.
Thank you so much, Meredith. I was taking notes like crazy. There's a ton of good information that you shared with us today. There are a few questions already, but then just a reminder to type them in, or when we have a quiet moment here, feel free to unmute and unmute yourself and speak up. The first question is, what's an average fee if we've already created a will and had it notarized, but this person would like to have a different attorney go over again with me in 10 years or so? And I guess I'd add a second question on to that. How often should we review our wills and everything that we've already created?
Great question. Okay, so with number one, if you have a lawyer, I would go back to them because it's probably going to be less expensive unless you didn't like them or they've passed away or retired. because they already have everything, right? So, but if you want a new fresh eyes on it, typically it will be hourly for that. I personally won't look at documents that have been done online and like affirm them, because it puts me at risk, and it's probably going to be less expensive for me just to redo something than make changes piecemeal for you. Lawyers typically range from like maybe $250 up to like $600 an hour. I do flat rate. So if I'm doing a package for you from the beginning, I will tell you what that flat rate is, right? And that incorporates everything from the meetings to the notarization to post-meeting questions, for up to a year. So, and I think a lot of lawyers in estate planning do flat rates because it's easier. I don't want you to feel rushed in any way asking questions. My fees in my office will range from a low end of about $750, usually in the $900 to $1,200 range, until you start looking at trusts, and then it's a few $1,000s. How often should you look at it? Some lawyers recommend every 5 years. That seems cumbersome to me. So I will reach out if tax laws change, right? Or there's major changes in the law. Otherwise, you should take a look at it anytime there's a major event in your life that may require changes. So birth of a new generation, death of anybody who's listed in the documents, divorce, absolutely, sort of move to a new state, looking at a move to long-term care. Those are all things, any of those major life events, it's good to take a look at what the plan is that you've outlined in the past and see if there's any revisions. You can do it first without a lawyer. If there's changes, definitely bring it to your lawyer. The advanced directive, I would take a look at every 7 years. So the healthcare documents, definitely take a look at those more frequently. Sometimes as we age or our children age, our ideas around keeping going, I guess, for longer might change. So yeah, major life events, take a look at it, talk to your lawyer. If you've already had one, anytime that occurs to you, retirement, right? Another major life event. You want to make sure that everything still is in line with what your wishes were.
Okay, thank you. The next, does the length of probate differ from state to state?
Yes, the length of probate and how probate is managed is definitely different state to state. So Washington has a much easier, shorter version of probate than Oregon does. In California, most everybody gets put into trusts because probate is extraordinarily expensive, even more expensive than what I've outlined here for Oregon. Every state has their own laws for how they handle probate. So yeah, it definitely, Washington is months instead of close to a year. And it varies county to county, to be honest. Some counties just are overworked, and so things take longer to get signed by the judge after we've submitted them than other counties.
Okay. Must any codicils, I think I'm saying that right, that are added to a will also be witnessed by 2 people and notarized?
Yes, any changes that you're making need to be in line with the rules regarding the will. So sometimes, if it's a small codicil, like a change to and a codicil is basically a change, right? We're making a change. If it's a trust, it's often called an amendment, but it's a written change to your will. It needs to have the same formal requirements that are outlined for the full will. If it's a major change to beneficiary, though, just for a little advice, like if you're cutting out a beneficiary, I would not do a codicil. I would do a brand new will. Anytime you're sort of like adding people in or taking people out from receiving money, maybe you don't want them to see what that last version was. Maybe that's going to cause a big fight. So just redoing the will. But if it's a change, if it's just a small change, or you're adding in new PRs, personal representatives, codicil is perfectly fine. Single page, couple witnesses, you're good.
Did you say that insurance companies pay out to the estate and not to beneficiaries directly?
So you need to make sure that if it's a policy that you have in place, you can add a beneficiary on there, right? And you need to always make sure with any of these, the IRAs, insurance policies, any of that, that you have beneficiaries, number one, and then successor beneficiaries, number two. Because if that primary beneficiary passes away, you're looking at probate again. Often though, with like if there was a death in a court case or insurance that is paid from like a car accident, that is paid to the estate, and that does require somebody formally to receive it on behalf of the estate. So there are less formalities if that's the only thing going through probate though, but we still do need a full probate typically for those.
Okay. Before we go on, just a reminder that this is being recorded and it'll be posted on our website sometime next week, probably. So if you couldn't take notes fast enough, you'll be able to go back and view it. And then another good thing about that is you'll be able to start and stop as you're viewing it. So the next question is, we joined everything together with my husband, houses and the bank account and the cars. Should this person still have a will?
Husband and wife joined everything together?
Yeah, the husband. So it sounds like everything's jointly owned. I think is maybe what she's saying. If the person who asked this question wants to pipe in, the houses, bank account, cars are jointly owned. Do they still need a will?
So yes, I would say absolutely, because if you pass away simultaneously or close in time together, then there's going to be probate, right? So, and we saw this a lot during COVID, unfortunately, where people would pass kind of close in time together. So if both of you pass away, then we need to say, or I'm guessing you would want to say who is in charge and who is to receive your assets. There typically is no probate between husband and wife, so long as everything is jointly held or has a beneficiary designation. Sometimes there's reasons we want to do probate, but that's beyond this topic. So between husband and wife, no probate. But if something happens to you guys simultaneous, then definitely probate. And to be honest, it's a great idea, if you guys agree, to at least know what the other person wants in their estate plan. Each one of you does a will. The will can be changed after a person, after, you know, if it's a husband and wife, the husband were to die first, the wife could change her will and sort of upend the whole estate plan that they thought they had. Trusts typically have some restrictions, or we can add some restrictions into trusts, but definitely, because we still need to figure out what happens after the second of you passes away. Where do you guys want the stuff to go?
Okay. My sole daughter is my sole heir and executor. Is she automatically my representative in probate? And is she automatically responsible for my debts? If everything is in my revocable living trust, does that avoid probate?
Yes, yes, yes. So sort of, right? So everything should be in the trust, so long as you've nominated her in the trust as the trustee. She is the one who will carry forth and pay those bills and do the taxes and kind of manage everything. If she's the sole beneficiary, she can kind of pick, you know, when she receives the money out of the trust. Everything should be in your trust. So if you've already established a revocable living trust, make sure everything is in there or has a beneficiary. So that means that, you know, the lawyer, if you used one, should have done the deed to the house, any real property been moved into the trust through a new deed. You should have gone to the banks to add those accounts into the trust, and they'll typically just close an account, open a new account in the name of the trust. She would have, depending on how you wrote it, but she would have rights both during your lifetime if you became incapacitated over those assets, and then after you pass away, as a successor trustee to manage all of that stuff. If there's assets held outside the trust, again, beneficiary designation will take care of all that. But if you don't have a will and you have one sole, one kid, unmarried, most likely that kid will be appointed. They are the natural part of that natural line of people who are eligible and have priority to act as your personal representative, and most likely the sole heir as well through those intestate succession rules. So.
You're a good attorney to answer this question since you have offices in both states here. We own property in Oregon and Washington. Is one state better to do a will in?
You own property in 2 states, I would probably maybe suggest a trust, a revocable trust, because you are maybe looking at probate in 2 states. Anytime we own property in more than 1 state, we will typically have a probate and then an ancillary probate in another state. That was a side note. So you need to probably do it in the state that you have your primary residence in, right? That is the state that has probably the most jurisdiction over you. But often we can pick and choose jurisdictions if you have property in multiple places. The will requirements are a little different in Washington. Like you can't, there's a presumption if a beneficiary is the witness that there's a presumption of duress. And so you need 3 witnesses typically, or just 2 and not include that beneficiary as your witness. So the rules are sort of different. Probate is way easier up in Washington. But again, for those of us that, well, not us, I don't have property in more than one state, but for people who have property in more than 1 state, a revocable trust is most likely going to be the best option for you.
Okay. My mom has both my brother and me on her banking account. Do we pay all the outstanding debts from her account when she passes? She doesn't do online. She only writes checks.
So you need to make sure that you are a joint owner on the account, right? Because sometimes you're listed as an agent and not a joint owner. So if you're an agent, not a joint owner, she passes away, you lose all your rights to access that bank account, probate's required. If you are a joint owner, either one of you has the right to sort of withdraw all the money. And so you would want to make sure that you're in agreement that the money from that account is used to pay all of her final expenses if there's not going to be a probate. Again, do her final taxes and work together to make sure that everything is complete before either one of you withdraw that money. But again, make sure joint owners, not just agents, because that will make the difference between probate and not probate after she passes away.
All right. A couple more here. What concludes a trust? What brings it to closure?
Yeah. So if there's nothing in it anymore, right? If we have completely defunded it, there's nothing for it to control. It might still exist, but it kind of needs to be able to control something. So often we can just pull everything out. I also like just something in writing, right? 1 page, I as settlor, which is the creator of the trust, hereby, close out this trust. If it's concluded after death, then there's certain formal requirements that should be done. Notices should be given to beneficiaries, creditors should be paid. We should do a final account. So Here's a list of everything that was paid out of the trust, making sure all the beneficiaries agree, sign waivers, and then we can close out the trust again by distributing the assets to the beneficiaries. Getting those receipts and waivers, though, is good for the trustee because it protects you from getting sued down the road. You gave them all the information that they needed. You gave them an opportunity to question, and they signed a waiver saying they're not going to sue you. So
I want to know how we can quit getting mail directed to those old trusts. It seems never ending.
no.
Let's see, what about
There is-
vehicles? Does the title have to reflect a trust?
Sorry, say that. Oh, vehicles. No,
Vehicles.
I typically do not put vehicles in the trust because there's an easy transfer through the DMV after you pass away. So spending that extra $100 to move the title from your personal to your trust is just a bit unnecessary. If the DMV ever changes that, then my advice would change, but no, and people buy and sell cars and they're high risk, so I typically do not move title into the trust.
Okay.
I have a question that I think you may not have seen, Margot. Do you have to be married a certain amount of time before you can receive the deceased's estate?
Yeah, so there is a law regarding marital share, and you have so yes and no, right? You can receive money, you can be entitled to money pretty quickly after you're married through the laws of intestate succession. There's an add-on to that even with a will and with estate planning documents in place, if you don't have a prenup, that a married person, based on the length of their marriage, has a right to a percentage, and that percentage goes up for the length of the marriage. Again, there's workarounds through prenuptial agreements and trusts and that kind of stuff, but other than that, and waivers of elective shares. But so it depends, because there's two sort of laws that come into place with that. That would definitely be something easily we could see in litigation if somebody was married for like a week and somebody passed away, right? So two different rules that kind of dictate that, though.
Well, I think that covers our questions. Are there any more questions burning in our audience?
It's April. I have not a question, but simply a thank you, Meredith. It was so well presented. I could really dig it. I mean,
Thank you.
remember it, but I really understood what you were saying. You were clear to me anyway, that it made other things come into place too. So I thank you.
Oh, good. Thank you so much. That's very kind.
And I really like how you said you always have an advocate on your side when you prepare these documents with the attorney. It's a really great thing to remember.
Yeah,
Yeah.
somebody to call and ask. And then, I mean, find an attorney that you feel comfortable asking questions. We get to know you really, really well, right? We get to know your history and the family dynamics and all of that. You want somebody that you're comfortable working with and telling the truth to, and somebody that you don't feel stupid asking questions, because most likely we have had that question asked before. You should never feel stupid or like that you feel like you should have to come in super prepared, because it's our job to really help you understand what it is that you're signing, so that your wishes are followed through.
I'm glad you understand so much. Ty, you have a question.
Yes, we did the prenup agreement over 17 years ago. Is that still active?
I would talk to a lawyer. Most likely, yeah. I mean, it's so much could have changed based on how you've managed your assets and estate planning documents that you've done since then. But that is a good question for a lawyer that would need to take a look at the prenup itself, what it states, and then kind of what you've done since then. Because you can upend a prenup by like merging your assets together, right? There's things that you can there's ways you can accidentally or intentionally change how the prenup dictates your life.
Okay, thank you.
You're welcome.
Kathy, are you having a question?
No, I don't have a question. I just wanted to say that she has been my lawyer for 10 years. And every time I call with a question, she's there to answer it. And I have been so grateful for her, knowing that she has my back for this whole time that I've been here. So thank you, Meredith.
Thank you.
Since before her daughter was born.
Well, thank you. And I think that expresses it for everybody, that for you to give us this time, realize that you may get more clients than you can handle. That is what I hear from elder care attorneys, is that there just aren't enough of us to keep up with what's happening as the boomers and the kids take care of their boomer parents. These questions are coming up, and so we really appreciate you giving this time. And we'll send out, or I do want to point out that we'll be having some more All's Wells That Ends Well presentations up in the coming months. We try to do one either in person or by Zoom every month. And Kathy, who just spoke, a testimonial to her lawyer, is the person that coordinates and keeps all those balls in the air. But this presentation has been wonderful, and the fact that we've captured it on a Zoom recording, now we'll be able to listen to it again and glean more from it, because as you covered a lot. And yes, and it is really just going back and referring. What exactly did she say about that? I think that people will find, even the people who've been in the session today will be looking at the recording. Thank you very much. And we're glad that all of you came. Everybody go out and enjoy the rest of this nice day, apparently.
Thank you.
Thank you.
Thank you, Susan. Thank you, Kathy. Thank you, Margot. Thank you. Thank you, everybody else I know. Bye.
That person singing to you is one of our workshop trainers.
Oh, I love it.